Hi, I'm Sharon Torek. I'm a marketing and intellectual property lawyer, and I'm principal of Torek Law and author of the Legal and Creative Agency Protection System. I've counseled independent marketing agencies nationwide for almost 15 years on their industry-specific legal issues, and I'm going to share some of what I've learned with you in a series of legal and creative law lessons. So here we go. In this legal and creative law lesson, I'm going to review 5 of the most frequently encountered legal issues I see marketing agencies experience and give you some quick tips to handle them at your agency. Legal hot button number 1, protecting your agency during the new business process. A lot of agencies are nervous about protecting their work and their original ideation and creativity when they're in a new business situation. But there are a few things you can do to protect yourself when you are going after potential new work. First of all, have a non-disclosure agreement. Not all clients will sign them. Not all agencies are comfortable asking for them, but have one in your toolkit so that it puts you in a good position to request it if it's appropriate. Secondly, make sure that in your actual assets that are used during the new business process, you use copyright notices and legends, and that in your proposal and any other written documents you present, that there's intellectual property ownership clauses in those materials. Another thing you can do is simply negotiate rights and compensation for your concept materials presented during the new business pitch up front. A lot of parties are choosing to do this now. It won't be enough compensation to make the agency whole for its work, but it settles the issue up front and it defrays some of your costs of pursuing the new business. Legal hot button number 2, using a virtual or freelance workforce. This is a trend in your industry that's not going away anytime soon. Most agencies, to deliver client assets, end up working with independent contractors or freelancers at some point. So there are a few things to put in place to make sure your agency is protected. First of all, always have a written agreement with your independent contractors. Remember that if you don't have a written agreement, you don't own the rights to the work that they create for you or your clients, even if you've paid them. And in that agreement, make sure you're addressing restrictive covenants like confidentiality of the agency and the client's business matters, as well as non-solicitation so that the freelancer doesn't go directly to work with the client without the agency's involvement. Legal hot button number 3, transferring rights to the completed work you do to the client. This doesn't seem like such a big issue because most agencies certainly intend that their clients own the rights to the completed work, but the magic is in making sure that the rights transfer at the correct time for the agency. You want to always make sure that the agency receives payment before it transfers rights to completed work to the client, and that's what your contract with the client says. Secondly, you want to always make sure you reserve portfolio display rights for your client's work in the agency's promotional materials. Legal hot button number 4, and this is for you agencies that do a lot of branding work, trademark clearance for client brands. There are a few tips to make you a little more successful in this part of your work. First of all, start with the trademark clearance process very early. Many agencies or brands make the mistake of moving a little too quickly without making sure that a potential new brand is available, so clear it early. Second of all, select brands that are very distinctive. You want to make sure that it's as highly unusual and unique as possible so that it can qualify for the highest level of trademark protection. The third thing to do is make sure your clients understand the due diligence that needs to happen before they adopt a new brand so that they're not holding you up on their end of the process. Legal hot button number 5 is legal compliance in social media and content marketing projects. The first thing to know is how to be familiar with the FTC's rules on testimonials and endorsements. Make sure that you and your clients are always being completely transparent on social and in content marketing, and that you're making all the necessary disclosures about the products that you're promoting. Secondly, be knowledgeable about the rules that each individual social media platform has for posting content. Every platform is different. Twitter, Facebook, Instagram, they all have their own rules of the road, and make sure you understand them before you use those platforms for your client's brand. Observe the intellectual property rights of third parties whenever you're posting their content. If you're reposting somebody's photos, somebody's writing, make sure you've got permission to do that and make sure that that permission is in writing. Finally, help yourselves and your clients by having clear written social media and content marketing compliance policies so everybody understands the rules. I'm Sharon Torek, and I really hope you found this information helpful. If you'd like more legal tips and tools for your marketing agency, go to agencylegalprotection.com. Thanks for watching.